Good evening, this is John Milburn for PROP13001 Property Development. This is the tutorial session for week 7. And this week we're dealing with construction. Now there is a formal lecture which is sadly a little like this with me to camera, although we do have Monica has joined us tonight, which is very good, thank you. And in that formal lecture I essentially worked my way through the content of the study guide. Now when you consider the study guide this week, there are a few elements where you need to pay particular attention. And I guess I can summarize where you need to pay attention by reference to the weekly problems. So there are problems that relate to the professional team that a property developer will put together for a construction project. There is a question about the different types of construction contracts that a property developer might consider engaging or entering into to construct a development. And in the problem in the weekly guide, hypothetically we're talking about the construction of, say, a retirement village. Then we have two questions that relate to alternative dispute resolution. Both have a common theme, and that is that it's dispute resolution, conflict resolution in circumstances where we are being proactive before the event in engaging in a process called partnering or engaging a dispute resolution board to assist in problem solving. Typically, ADR deals with conflict after it has occurred, but this is a proactive methodology used for construction contracts, and the idea is to be proactive, anticipate where disputes may occur, and ultimately provide for increased communication and an informal means of receiving advice, recommendation by way of a ruling. Then finally, we move on to issues to do with risks associated for construction for a property developer. And really there are two types. The first relates to the risks that might be inherent in a claim for negligence. That could be as a result of injury or loss sustained. And the property developer needs to be aware that with changes to the Work Health and Safety Act 2011, last year, the Queensland State Government has introduced criminal and civil penalties, including jail terms of up to 20 years for individuals, for things that may occur within the confines of a construction site. That would be death in certain circumstances. So the Civil Liability Act 2003 is also relevant in those circumstances. And finally, there is a question about contractual chain scenarios. So when we talk about a contractual chain, we're talking about essentially who might be in the firing line if something goes wrong, and it really revolves around the legal relationship between a property developer and a contractor engaged to complete a property development. So if you look at the problems first, and then work your way back through the study guide, through the formal lecture, and indeed what we're dealing with tonight, that might be an appropriate way of preparing for not just essentially the first assessment, but now we're getting into preparing for the exam mode. So over the next 5 weeks or so, I'll be providing you with more hints in that regard. Okay, so what do we take from the lecture notes in relation to construction this week? Well, I guess the first is that there are different ways that a property developer might engage a contractor. You need to be aware of the different styles of contract. I don't really need you to identify particular clauses of contract, although there are some that are more important than others, and I do highlight a couple. But really at this stage, it's the style of contract that I'm interested in you understanding and being able to argue for and against if you are advising a property developer, or indeed if you are the property developer. The traditional approach is one where the property developer will design a project, usually in conjunction with an architect as the lead consultant, and then place that design out for bids by way of a tender process. And after the successful bid is accepted, a contract signed, then we, of course, build the project. That's the traditional methodology. It has a lot of advantages, some disadvantages. the property developers remain in control, but it does add to the time, the cost, and to some degree uncertainty. Also, there are tactical issues. How do you engage the architect? What is the design brief? How do we try to avoid, as a property developer, creating something which is great, but way beyond the budget, and having to waste, and then wasting time and money in trying to rectify and reverse that situation? How do we deal with the tender documentation? How do we ensure that the bids come in comparing apples with apples, so to speak? So the way in which the property developer controls the tender process is very important in that concept, that traditional approach. The property developer also acutely needs to be aware of cash flow considerations at the stage of design and bid, because there's no point in putting out a proposal which is accepted only to find that you can't comply with the obligations to make the progressive payments, or your funding model just doesn't allow for it. So there are a whole lot of things that you need to do at that early stage. Another thing that you might consider in that traditional approach of design, build, and bid and build is the issue of retention monies and how you make some provision for the contractor to rectify faults should they arise. All of that is done at the outset. So a lot of planning before you even get to the stage of designing something ready for tender. The next one is a very simple modification to that traditional approach, and it is an approach of design build. So no bids. You're essentially, as a property developer, approaching a contractor to undertake the design and build the project. You are putting a lot more faith in the contractor. You are, in a way, losing control, but at the same time, quite oddly, gaining control. You're gaining control because you are now dealing with one organisation rather than necessarily a team. So that means that you have more, in a sense, more control. It's not your resources aren't being separated. You might have more control in that you now have the opportunity for the contractor to come to you with design concepts and costings, so that you're getting to an answer which is acceptable at a quicker stage. There are disadvantages, of course, with that, in that you're only dealing with typically with one contractor, and as a result of that, you might be left to rue the fact that had you designed the property development, put it out to bid, you may have secured a tender price far less than the price that you agreed to under the design build proposal. So that's, there are a couple of options. An alternate approach is to look at management contracting. Another way is to look at project management. So there are different styles that you can use as a property developer when considering the type of construction contract that you wish to engage in. All right, so once you've decided on the type of contract, then there's the issue of regulation of the construction. The Building Act, Queensland, is obviously very important. You'll need to refer to that as part of this chapter's readings. And associated with the Building Act, you have the Building Regulation and the Queensland Development Code, which is part of the Building Code of Australia. Have a look on the department website for further information about that. I've already talked about partnering. I've already talked about dispute resolution boards. So they are, as I mentioned, different forms of ADR, but proactive forms of ADR. Then consider the really important issues of duty of care, civil liability. There's a bit of law in this, so you need to look at the Civil Liability Act 2003. And importantly, you need to consider the changes made by the Queensland Government to the Work Health and Safety Act 2011, where in relation to industrial manslaughter, for example, there are now very severe criminal and civil sanctions associated with people conducting a business or an undertaking, or people who are senior officers in an organisation undertaking a business or undertaking where someone has died or is injured and then later dies, and that negligence is attributed to the people that are effectively in control of the process. The Queensland Building and Construction Commission provides some really good flowcharts. They're in the study guides, they're in the reading for this week, which provide for an overview of the responsibilities of each of the parties in relation to domestic contracts or commercial contracts. And it's a good way of reviewing, if you like, the risk factors associated with a property developer entering into a construction contract. So there are a few things that you need to consider this week. If you have any information, if you have some links to websites, if you have some pro formas, for example, a construction contract, subject to copyright, of course, feel free to share information, documentation on UCREW. And whilst we're getting some questions coming through on UCREW, I really would like to see a lot more activity there and a more interactive approach between students. You can always email me and I'll happily provide any comments by way of a response to you, but almost invariably, I'll invite you to re-ask the question on UCREW. And then I'll repeat my answer so that everyone has an opportunity to share in the discussion and my thoughts. And from my perspective, I can say that very often students provide very good responses to each other to answer questions or provide an explanation. Okay, so that's a very quick overview of this week's reading and the material that you'll find on the website. Do have a look at each of those links. When it comes to the legislation, you'll see that the legislation is extensive. We're not training you as lawyers, so I don't need you to read and understand all of that legislation. But a good way to look at legislation is to consider the headings and get a feel for the overall act. So don't just start reading, have a look at the headings, get a feel for it. And remember this, that if you look at the explanatory note or explanatory memorandum, that will provide you with some very good commentary about what each one of the sections mean. It's a document prepared through parliamentary process leading up to the enactment of the legislation, and it gives you a good idea of what that section or why that section has been introduced, what it's intended to say, and what the effect of that section is likely to be. So if you want some better understanding about particular sections, have a look at the explanatory notes, explanatory memorandums, or even the Hansard for the second reading speech. Okay, I've been doing a lot of talking. That's probably all that I intend to cover tonight. Monica, without putting you on the spot, do you have any questions or comments?
No, I'm good.
All good? Okay. Yeah. Well, it looks like we've got a very quick night tonight.
Okay.
If I had something else that I wanted to share, I would. But please ask questions through UCREW. Just a reminder, if you're watching this as a recorded session, your first assessment piece is due Thursday week. That is Thursday, the 3rd of May, 2018 at 11:45 p.m. Just a few things about the assessment. Watch out for word counts, but I'm not that tough on word counts. If you need to go beyond, try not to go more than 10%. If you go beyond, irrespective of the amount, I will look at it, but I'll be very critical as to whether you actually needed those words and use them wisely. If I deem that you wasted the words and you've just padded the material to go well beyond the word count, then in that circumstance, I will punish you in terms of a mark. If you need an assessment extension, then please ensure that you apply through Moodle in the usual manner and do so before the assessment is due. I won't accept any applications for extensions after the event. If you are late with the assessment, bear in mind that you'll lose 5% per day for each day of late submission until the cut-off date. So 9 days after the assessment is due, I will cut off the further assessments. So that means the Saturday week, typically. What that means then is that you can lose up to 45% of the assessment. But if you're more than, if you're 10 days late or more, then you'll get a 0 mark. So please submit your work on time, and remember that the first 50% of marks are much more easily achieved than the second 50%. By that I mean, don't stress too much. Don't necessarily think that you have to provide something that is absolutely perfect. In particular for the assessment piece that relates to the toolkit, it's really something that I want you to design for yourself. You can be a bit selfish about this one. The idea is that if you are a property developer, or if you are advising someone who is a property developer, you can actually go to your toolkit and seek answers for yourself in terms of procedures, links, legislation, materials generally, anything that you think will help you in that process. Of course, there are things that you'd expect. Absolutely, certainly everyone's going to have a cash flow projection. If you do that within Excel, just provide a link within your Word document to the Excel document, or email the Excel document to me. Do something, because I think Moodle will only allow you to upload one document. So don't think you have to have everything contained within the one document. You can have links to other things as well. I make that comment guardedly because I don't want you to send me 100 documents, if you know what I mean. All right. Any questions, comments? All good?
All good.
All good. Okay. Well, all the best. We'll see you next week. If there's any questions, please ask through you, crew. And thank you, Monica, for attending tonight.
Okay.
All the best. Bye, Jen.
Thanks. Bye.